Thank you. Hey, good evening and welcome to the Thursday, June 16th, 2016 meeting of the Auburn Zoning Board of Appeals. Before I get started, do I have anybody recording the meeting this evening? Okay, hearing none, seeing none, thank you. Before again I begin, we have a little bit of an administrative request. So we have several hearings scheduled for the same matter, in essence. We have a 7 o'clock special permit, a second 7 o'clock special permit, and then a 7:05 variance, all pertaining to the applicant Gloria LaBeouf, trustee, requesting under section 3.2.2.1 and 9.3 of the Auburn zoning bylaws to allow two-family occupancy use on property located at 514 Rochdale Street, Auburn, Mass., map 52, parcel 7. So, if I may, before we begin, just as an administrative thing, could the applicant please approach the lectern or the representative?
Good evening. My name is Bill Ritter, and I represent Gloria LaBeouf.
Thank you. So what we're trying to accomplish here is just basically it's an administrative issue that we want to correct before we begin. The second application on the agenda, the 7 o'clock applicant for Gloria LaBeouf for the special permit, should go first. Okay. It was listed incorrectly because I believe of the continuation from 7/16/15. So what we'd like to do is we'd like to hear the second 7 o'clock hearing first, then move on to the 7:05, and then back to the original.
Could I make the suggestion that you just open all three public hearings, because it's essentially the same arguments. There's some separate legal arguments for some of the variances and special permits, but it's all the exact same issue, and I would hate to have to make three separate presentations of the exact same information.
And it's not for the purpose of making three separate presentations at all. It's just for us for an administrative duty to make sure that everyone is clear that we will be beginning the hearing with the second 7 o'clock applicant. I will open for all three, but we'll be addressing them in the order of basically 2, 3, and 1 as it appears on our agenda.
That'll be fine.
Okay, thank you. Okay, so good evening, everyone. How are you? Now that we have that squared away. Do I have a motion on the floor to open the meeting?
Motion to open here.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Okay. So with that being said, the second hearing on the agenda, the 7 o'clock applicant Gloria LaBeouf, and I'm just going to read for the record. Trustee requesting a special permit under section 9.3 and 9.3.12.6 of the Auburn zoning bylaws to allow an accessory apartment in an owner-occupied single-family dwelling on property located at 514 Rochdale Street, Auburn, Mass., map 52, parcel 7. Again, if the applicant could approach the lectern, please. And I apologize, sir, with the air conditioner on, if you could just speak up a little bit for us this evening.
Sure.
Thank you.
And are all the other public hearings going to be opened?
So, yes, I would like to actually begin with another motion if we could open up all the public hearings. We are going to address them individually, but for the purpose of the meeting.
I'll make a motion to open all three public hearings.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? None. Okay, so with that being said, they will all be open.
Great. Thank you very much. Can you hear me okay now?
Yes, thank you.
All right. Good evening. My name is Bill Ritter, and I'm an attorney in Worcester at the law firm of Pajani, Hurley & Ritter, and I represent Gloria LaBeouf, who's the owner of the property at 514 Rochdale Street. This is sort of a long and tortured process, but I think in order to address all the issues that are going to be before the board this evening, it's probably worth going over some of the history so that all the members can have an edification of the things that have gone through in the past historically and all the work that's been done on Gloria's house on Rochdale Street. Gloria's roots in the town of Auburn go way back. The house that she currently lives in, that's the subject matter of the hearings tonight, was actually built by her parents in the early 1950s, and Gloria lived there as a child. She moved out of the house sometime in the mid to late 1950s when her family moved, but when the house came back on the market in the early 1970s, she bought it with her husband and her family and lived there since 1971. In 1992, she obtained a building permit and put a dormer on the back of the house. Didn't change the footprint of the house. She was expanding it because she had additional family living with her. She had her son and daughter-in-law and their children staying with her at the house. And over time, they moved out, and by the mid to late 1990s, she essentially rented out a portion of the house. And it's been like that for over 20 years. It's only a 2,000 square foot house. It's a heavily wooded area. Her house is not near any abutters, and there's never been any issues or problems with her as a resident of the town of Auburn. In the summer of 2014, a dispute erupted with one of her abutters. And what essentially happened is the abutter said that her driveway that she's been using for over 60 years, the only access to the house, was on his property, and we had a boundary line dispute. But it was a little more than a boundary line dispute. There were a number of problems with the abutter in terms of harassing Gloria, putting up a fence that was going to go across the driveway. It got so petty that she couldn't even bring her trash down without him moving the trash from the road. The abutter filed suit against Gloria in the land court in Boston in the summer of 2014. At that time, the abutter's then lawyer, not the current lawyer, brought some complaints to the town and said that there's an illegal two-family going on at Gloria's house, and therefore the enforcement action started. My office, as part of the lawsuit, had to obtain an injunction against the abutter so that she would not be continually harassed and that she could bring her trash tote down her driveway and have it picked up like every other Auburn resident. Needless to say, the enforcement action started in November of 2014 when the then building inspector issued a letter saying she had a illegal two-family. When Gloria got the letter and she brought it to my attention, I came down and met with Caleb, discussed the issue, determined what needed to be done to correct it, what needed to be filed, and after my meeting with Caleb, the only documents that need to be filed with this board was the special permit to permit a two-family house. In March of last year, we had the first public hearing on the matter. The application was actually filed shortly thereafter in February. I did a long presentation at that hearing quite a while ago. Told you all the issues. We talked about the special permit, and I think the board's biggest concern at that time was the condition of the property and was it up to code. And so what the board, not to speak on your behalf, but they requested Caleb to go inspect the house, make sure everything is done up to code, make sure it's safe, and identify any problems. That was the March public hearing. There wasn't an April meeting because it was postponed, but during March and April, the plumbing inspector, electrical inspector, Caleb, and the Board of Health all came to inspect the property. The plumbing inspector identified a number of minor plumbing issues that needed to be corrected. There were some small, pretty minor electrical issues that needed to be corrected, and the Board of Health requested that a Title V certificate be issued for the property. In May of 2015, Gloria retained the contractors to do the work. We obtained a Title V certificate showing that the septic system was fine for a 4-bedroom system. Along with that, we also got a well test just to make sure there were no problems with the well, and everything was positive. In June, the Board of Health received the Title V certificate, and because of inconsistent documents historically in the file, they were concerned that the system wouldn't support a 4-bedroom septic system. And so the Board of Health issued another letter which said your options are to install a new system or do all sorts of calculations which would have required her to dig up her existing septic system, or ensure that the building will only be a 3-bedroom house. In July and August of last year, the work was undertaken to repair the electrical. The work was undertaken to complete the plumbing issues. The work was done to comply with the 3-bedroom requirement of the Board of Health. which, although some of the correspondence talks about a 5-bedroom, it really was only a 4-bedroom because the 5th bedroom was a basement that had a closet in it and a rug. So there really wasn't a 5th bedroom in the basement. So Gloria took up the rug, took the paneling down, which was no big deal. With respect to the 4th bedroom, she took a wall down to make it not a bedroom, and all those matters were inspected by the building inspector and signed off. They all obtained the appropriate permits. I think Caleb will confirm that all that work was completed and up to code. Is that true, Caleb?
Yes.
Okay. While that work was in progress at I think it was our July meeting, for the first time, one of the board members raised the issue of whether a variance may be required. And at that time, I think a little bit off the cuff, Caleb suggested that maybe a variance should be required, which sort of set the whole process back yet again. So we submitted a zoning determination form to the town. Caleb issued an opinion that he thought a variance was required. I disagree with him, respectfully, of course. In September, I sent a long letter explaining why I didn't think a variance was required and that a special permit was all she needed because it was a pre-existing non-conforming building, and the zoning changes which Caleb was concerned about are not applicable to 1- and 2-family homes. It took a little while for town council to respond, and I think he issued a letter in January of this year. He agreed with Caleb. I think I told the board members I respectfully disagree with Bob Hennigan. He's a great lawyer, but it's not unusual for 2 lawyers to disagree, especially on a fairly complicated nonconformity issue. And my letter is about 6 or 7 pages, and I think Bob's is even longer. And so we've just agreed to disagree. We came back after those letters were issued to a hearing, I think in April or May of this year. The board made it quite clear to me that they wanted a variance to be filed to go along with the special permit. My legal position is that variance is not required, but I suggested to the board that we've gone this far in cooperating in every respect with the town of Auburn, and that certainly we would continue to do that, but that I would file a variance petition without prejudice to my legal position that the special permit was all we needed. So we filed the variance, which is application number 2 that is pending. So we have the special permit to change it to a 2-family. Number 2, we have a variance that was filed. At the beginning of this year, Gloria's tenants moved out and her grandson moved into the property with his girlfriend. And I spoke to Caleb, and looking at the accessory apartment bylaw, it seems pretty clear that as long as Gloria would remain in the house, she's entitled to a special permit under the accessory apartment bylaw, as long as she complies with the state building code, subject to your special permit requirements. So we filed a 3rd application, which is the special permit under the accessory bylaw. And that's actually one of the most straightforward and simple filings that were made. The only thing that was required is I must follow the same procedures for the accessory bylaw, which is a letter from Gloria saying that she's going to live there and is notarized, and it's been submitted with the package, and that it would expire if she moved out of the house. And so it's essentially the benefit of the 2-family, but it's personal to Gloria. So it's only in effect as long as Gloria is living there. And so that application was filed, which would be another way for Gloria to continue to reside in the property, have her grandson live there with her daughter, and not have any problems with the variance or the special permit that was first filed. The difference between the two is that with the first special permit and the variance, she could essentially have a 2-family house and not even live in the property. She could rent out both units. And so as a compromise position, Gloria's also filed the accessory bylaw application. She clearly meets all the building inspections required because it's been inspected by the Board of Health, the building inspector, the fire inspector, the DPW guy. Everybody's been out there to look at that place. It has been the most inspected house in the town of Auburn. And so there's no issues about its compliance with the building code. And so that's the 3rd application that's pending before you tonight. The special permit requirements for both special permits, I'd suggest, are clearly met. As you may recall, this is a 1-acre parcel of land that Gloria has. There's no new construction, there's no changes to the building at all, there's no increase in municipal services, there's no impact to the town. It's consistent with your master plan, which is stated in numerous cases, which I've cited before the board, which is to encourage older residents to stay in town so they can afford to be residents for longer periods of time. And it's also consistent with the intent of the accessory bylaw provision, which says exactly that we want to encourage older residents to stay in town and make it affordable for them. It's also consistent with the wishes of her abutters, because as you've seen from the applications, 4 of her abutters have actually submitted letters supporting her position to have a 2-family there, or by analogy, to have her grandson live there with the accessory bylaw provision. The 5th abutter who didn't submit a letter actually has got a special permit for a 2-family. That's the house just to north of Gloria's. And there's one other abutter, and that's the abutter who's we've been involved in a lawsuit for the last couple of years, which actually went to court a couple months ago, and I suspect will have a judgment in the next 3 or 4 or 5 months. So the other matter I just would like to say with respect to the abutter who has been opposing this, that property is on a 16-acre parcel of land. You can't see Gloria's house from that house. Physically, it's the houses are 2 football fields apart, over 200 yards. And I think you can tell Gloria's commitment to the town of Auburn by all the work we've done, by the degree of cooperation we've given to the board and to the building inspector, the Board of Health, getting all the work done as required by the town officials to make sure this works, because she wants to be in Auburn for a long time, and she needs to have somebody living with her if that's going to work. So I would urge the board to grant special permit. This might not be in your order, but it's easier for me to grant the first special permit that's been pending for quite a long period of time, to grant the variance, and also to grant the second special permit on the accessory apartment bylaw. I know that's a lot to grasp in a short amount of time, but I'd be pleased to answer any questions you might have.
Okay, thank you. I'd like to open up to comments or questions from the members of the board. Mr. Cussy?
I have none right now.
Okay. Mr. Chicolo?
I also have none right now. I'd like to hear the response.
Okay. Mr. Marin?
I have no questions, Mr. Chairman, but I would like to hear from the building commissioner on the matter this evening.
Okay.
Did you have a specific question, or?
Well, relative to where we bring ourselves to today, recommendations on the applications that are before us.
I don't know that I can make a recommendation on anything.
So you have nothing to add, other than what we've heard from...
No, I don't.
I don't have any additional questions at this time.
Thank you. Ms. Roach?
I'd like to hear from the abutters first.
Okay. Are any abutters present? Okay. I'd like the abutters who have participated in the hearings for quite some time participate first, and then we'll allow you to come up second, if you don't mind. Thank you. If you'd approach, please, sir, and introduce yourself and bring us up to the present on your point of view.
Good evening, members of the board. I'm attorney Michael Patnode, here representing Janet and William Keeler, who, as was indicated, reside right next to and abut this property. Incidentally, every time we've come here, just for background, my clients have been impugned about how they're harassing this lady, and there's never been any evidence that they have harassed her. There's never been any evidence that I have seen that they've done anything to her trash. These are allegations that she has made. I've never seen a shred of evidence supporting it, and yet every time we come here, we keep getting this attack on their character, really, which I think is just out of line. The reason we're here is not because of a neighbor dispute. It's because 20 years ago, or plus 20 years ago, Ms. LaBeouf decided to put in an illegal apartment. That has nothing to do with my clients. She got a permit for a single-family expansion, and what she instead did was put in an illegal apartment, which she operated and rented out for many years. And the town finally caught up with her and obviously sent the letter from the building inspector citing her and indicating that she needed to correct that. guess what I will do is start in this, go in the same order that Attorney Ritter did. In terms of the variance, it was the opinion of Attorney Hennigan, the town council, that a variance was required. And I think it's clear that this lot does not meet the zoning requirements. It is a significantly undersized lot. It's for what she wants to do, she would need to have 80,000 square feet under the zoning bylaw, and she has 44,867 approximately. She has brought forward the variance petition, and in order to grant a variance under the bylaw and under the statute in Massachusetts, there needs to be some unique circumstances, some unusual circumstances relating to the soil conditions, the shape of the lot, or the topography of the land that then creates something that's unusual for the area that creates a hardship for the person. And I would submit that none of those things are present here. What we have is a lot that is quite typical, I submit, of the other properties in the area. The application says that the lot is wet, but there's been a house there since the early 1950s and hasn't interfered with the use of the property. And I submit that there's no special soil conditions, and certainly we haven't seen any evidence of any soil conditions which would justify a variance. The topography of the lot is characteristic with the whole area. This is a neighborhood that has a lot of hills. It's cited in the application that the slope of the lot goes down to the street. Well, that's basically a description of everybody on Rochdale Street, including my clients, who have a much more significant slope. What is unusual about this lot is that it's too small. This is a lot which is significantly too small. And under Massachusetts law, and I've cited in our brief, the fact that a lot is undersized is not a basis for a variance. That is just simply not grounds for variance. As far as any hardship, in order to get a variance, you need to show that there's substantial hardship that relates to the unusual character of your lot, the soil conditions, the shape, the topography. There's simply no evidence before the board to support any kind of allegation like that. There is an allegation of a personal hardship, that there's a financial issue, and that may be true, and we may be sympathetic to that. But that's not a basis for a variance. And the Mass case law is quite clear, as I've cited in our brief, that personal hardships are not relevant when we're talking about a variance. And we also have a self-imposed hardship. And again, Mass case law is quite clear that if someone has a self-imposed hardship, that does not justify and cannot justify a variance. She put in an illegal apartment. She did it on an undersized lot. She did it quite a long time ago, probably because it was on an undersized lot and knew she couldn't get the permit. The neighbor that's referenced, who has an accessory apartment, and we submitted this the last time we were here, has a lot that complies with the zoning size requirement. So I submit that there's no evidence that's been submitted which would, under Mass law and under this bylaw, justify a variance. As far as the accessory apartment bylaw, there's a very clear accessory apartment provision in the bylaw which provides for someone who wants to put in a new apartment, and there's a whole procedure, or somebody who has an existing apartment. Well, here we have an illegal apartment, and I guess the position of Ms. LaBeouf is that under 9.3.12.6, which governs accessory apartments already in existence, that her interpretation is that she doesn't need to comply with the standards of the accessory bylaw that are quite detailed and are laid out. And I just submit to the board that that's completely wrong. If this board is to issue a special permit, whether it's for an existing apartment that's been around for a while, and now she's trying to come into compliance, or a new applicant, the standards which are detailed in 9.3.12.3, accessory apartment standards, need to be complied with. And again, I suspect the reason that is not being brought forward is because she knows she can't comply with them. The standards in Section C say that the lot in which the single-family house is located must meet the minimum lot size requirement and must comply with other applicable zoning requirements. She can't do that because, again, she has a significantly undersized lot. This is a lot of 44,000 square feet, and she's got a 80,000 square foot requirement. So I would submit that to adopt the argument that she's making is to totally undermine the bylaw and to say, okay, you have an illegal apartment and we're going to allow you to come in and get a special permit, and we're not going to have you comply with all the requirements that we require everyone else to have for an accessory apartment under the bylaw. And I submit that doesn't make sense, and I can't see that that's the way the board would read this and interpret the bylaw. I have nothing further.
Okay. Thank you very much. Okay. The next abutter, please, if you could go up to the lectern, introduce yourself, give us your name and address, please.
Good evening. I'm Kelly Fant, and this is my husband, Bruce Fant. We live at 522 Rochdale Street. And I think I'd like to talk on behalf of both of us in saying that as neighbors up there and abutters, we have no wish to get involved in any dispute with Gloria LaBeouf or the Keelers. We're here primarily for our own interests. I'd like to clarify that when you had your first hearing, I did supply a letter stating that we were okay with having a two-family or Gloria having her family live with her because of financial hardships. The reason that we're here this evening is because we are not okay with the variance on the lot of the 45 and the 80 square footage. We're thinking that it's not anything against Gloria particularly, it's how it's going to impact us as landowners up there and homeowners in the future. We don't wish to see a bunch of two families up there. The reason that, my husband and I are born and raised in town. We've lived here our whole lives. We've owned a home over off of Bryn Mawr Ave for 20 years, raised our family there, and about 9 years ago, we moved and built up on Rochdale Street for privacy and solitude, and it's been very nice, actually, and we really don't want to see a bunch of two families up there. I don't want to say that we're opposed to an accessory unit or whatever, but we very much are opposed to the zoning.
Okay.
I'd like to clarify, the letter that I did provide said that we had been neighbors for 20 years. We've actually owned the land around that, maybe 19, but we didn't build on it until 9 years ago. But certainly, I just want to reiterate on behalf of my husband and I, we don't want any wars with any neighbors. We don't want to, this isn't a personal thing. It's something for our own interests.
Okay.
Thank you.
Thank you very much. For the record, are there any other abutters present that would like to speak? Okay, there are none. Again, I'd like to open it up to the board. Mr. Cussy?
Question for Kaylee. As far as the accessory apartment, been in there and it meets all the requirements of an accessory?
I couldn't say for sure what the square footage is, but I think the way that the statement of intent, it's written in the bylaw for existing accessory apartments, I think it's the board's discretion. As long as it meets the building code, and we've determined that it does, I think everything else is up to the board's discretion on existing units, is the way I interpret the bylaw.
Chicolo.
Yes, I do have a question, and it would be directed to the attorney opposing. I see your brief, and your brief begins and is targeted mostly at the variance, and you have a section here that you speak to the special permit, which would be referring to the accessory apartment. You have stated here that the two things. The front and the rear setbacks of the property are 40, 20, 20 respectively, and no evidence of compliance with these setbacks has been submitted by the petitioner. And I would say to you, if you are questioning that, and you have stated the numbers here, what evidence do you have that those setbacks are not met?
I don't have any evidence that that hasn't been
Would
met.
you move that microphone up, please? It's where I couldn't hear you.
I'm just referring to the requirement, and I have not seen any evidence
So
that there
you have nothing to support
No.
your statement here?
Well, it's just indicating that the board needs to determine that question.
But again, you're questioning it, and you have nothing to support that.
I'm merely pointing out that it needs to be complied with.
Okay, so that you're not putting forth that requirement has not been met. You're not stating that?
I'm not stating that at all, no.
Okay. The next thing that I would bring up to you is that you're saying that under statement from Gloria that her apartment or that her accessory apartment is approximately 500 square feet, and that, yes, it's below, we can tell by the numbers, it's below 700. But you're stating that the original building, it increased, you've speculated that it increased the original building size by more than 20%. But you have no facts to support that accurately either.
What we actually do have is the original building permit, which is attached as Exhibit 1, and that does provide those numbers.
Do we have a number on the building permit? I looked at the building permit, and I don't see where this is referenced as either 700 square feet or more than 20%. And I would say that without anything to support your statements, that your argument to deny the special permit would not be supported.
It is not contained in there.
Okay, I just wanted to establish those two things.
That reference was from the original materials that we had, which we did not attach, which is an error.
That's all I have, Mr. Chairman.
Thank you. Mr. Maron?
Thank you, Mr. Chairman. Caleb, if I may, and I want to apologize for asking you for opinion, it wasn't stated correctly. Could you, on the, and I know we did cover this in the last meeting, could you just remind, I know we have the brief from the town's attorney, could you just, for the record, affirm that it's the town's attorney's opinion that a variance would be required to move forward?
I believe the variance would be required to move forward on the two-family. On the accessory apartment already in existence prior to the bylaw states that the board will review each existing use on a case-by-case basis to determine if the dwelling conforms to the state building code. It goes on to say that the applicant must follow the same procedures. I understand that to mean that they must follow the same application procedures, but as far as meeting all the criteria, I believe the board has the ability to review those cases on a case-by-case basis.
Thank you for those comments, and apologies for misstating my earlier question, but that's exactly what I was hoping to affirm earlier. Thank you, Mr. Chairman. I have nothing further at this time.
Thank you. Ms. Roach?
I guess I do have at least just one question for Attorney Ritter. Do you know, and I'm sorry if this is being reiterated, but do you know what the square footage is of the accessory apartment?
The apartment where Gloria lives in a smaller apartment. It's approximately 500 square feet. I know Caleb, as part of the process, Caleb did some diagrams, understanding they're not to scale, but they're submitted as part of the record. I do have copies if...
Are they the
But it's-
handwritten?
Yes, as
Okay.
part of the review, Caleb was
Yeah.
kind enough to prepare a sketch. The assessor's office has it at approximately 2,000 square foot building. Her apartment is approximately 500 feet, which is in the front of the building. And if I just may want to address the issue of the bylaw is very clear that the applicant must follow the same procedures described. And in the accessory bylaw, there's a whole section on procedures. There's also a whole section on standards. And if we were required to comply with the same standards, it would say they must follow the same procedures and standards. It's clear to me, I mean, I wasn't here when this was voted in, but the purpose of this accessory bylaw, especially this provision, was to legalize conversions and encourage compliance with the state building code, which is right in section .12, section D. And the standard that this board needs to review, in addition to the special permit standards, is to determine if the dwelling conforms to the state building code. And I apologize for going through the litany of review that this house has gotten. I think it's pretty clear, and the building inspector's made it clear, that the property clearly conforms with the state building code.
Anything else?
Not for me.
Okay, thank you.
Thank you.
Anything further?
Just to confirm, we are strictly now going to be, or are we now strictly going to be conferring on the second meeting?
Yes, so just for the record, so I believe that we will be voting each individual. We've heard, as agreed by the petitioner, the attorney, and all parties concerned, that will be addressing the second 7 p.m. agenda for the special permit under section 9.3 and 9312.6 of the Auburn zoning bylaws. And then we will address the 705 applicant requesting the variance, and then we will go back to the original first one on the item agenda this evening, which is section 3.2.2.1 and 9.3 special permit. So we have one for an accessory in apartment, which would be the one we're going to address first. The second one would be the variance, as it pertains to, as we know, the land. And the first one would be allow a two-family occupancy use on it. Okay, so they're all three separate issues, but we've addressed them all this evening during the same hearing.
And as a matter of administrative matter, do you propose that we will be holding three separate votes?
Yes. In fact, I believe that would be the correct way to do it, and that's the way I would prefer to do it, unless the members of the board have any other opinion.
I have another question.
That's okay. Okay.
I have one more question.
Yeah, absolutely, please.
Me too.
Would you know, like, on the accessory apartment, does the lot size have to meet just the single-family lot size, or does it need the two-family square footage?
The way I interpret the bylaw is you're dealing with something that's already in existence. I believe it's it's your discretion as to whether to allow it or not. I don't believe that I don't think you have to look at all the standards for the new bylaw, the new apartment, I should say.
You comfortable?
Yeah.
Okay. Ms. Roach?
Sorry, again, I just have, Attorney Ritter, again, I'm sorry, just one other question. I'm still on the square footage issue. Do you know what the square footage of Gloria's house was prior to the addition of the accessory apartment?
Well, I think they just put a dormer on the roof. They didn't expand the footprint. I don't have the exact measurements of that.
I think it says here like
Because
800 square feet.
It says in both briefs that the total
Addition was 26 by 32.
the total square footage is 2,028,
Original size of the house.
and I assume that includes the accessory apartment?
That's correct.
Okay.
Okay, think that's from the
So-
assessor's office for the whole property.
Okay, so essentially then, rough numbers by default, if her apartment is 500, original is about 1,500.
That's correct.
Okay. And
Refer to the,
if the abutter has any comment on that issue, I'm happy to hear it. I'm just trying to get my numbers straight.
she's in this.
Thank you.
accessory.
Thank you.
I'm good.
Okay, just for the record, the abutters attorney had no further comment on that issue.
Thank you.
Okay. Do we have anything further?
Close everything.
Yes. So I'd like to make a motion to close the public hearing.
Motion to close the public hearing?
Second.
All in favor?
Aye.
Aye.
Any opposed? Okay.
No.
So before we go any further, I just want to spend a minute. I want to say thank you to everyone. I appreciate your patience and diligence during this whole process. I know it's been long. It's been a learning process for some of us that are on the board. I can tell you, from my point of view, being on this board for many years, that this is definitely the longest and most in-depth hearing that we've been involved with. It certainly is complex. And also, out of respect for everyone here and present this evening, I want to make it clear that when the board makes their decision, we are focusing solely on what is in front of us in terms of the Auburn zoning bylaws, what took place regarding land court issues or neighboring issues does not pertain to us, does not pertain to the decision. My hopes in entertaining that would be that maybe some dialogue would be opened up and some type of understanding would have been reached before we have gotten to this process. Clearly that did not happen, but I just want to make sure that, please understand that our decision is going to be based solely on the information that we have in front of us this evening regarding the bylaws in town. Okay, so with that being said, do I have a motion or a discussion, I'll entertain that as well, for the applicant under section 9.3 and 9.3.12.6, I'm going to read the whole thing, please be patient, of the Auburn zoning bylaws to allow, this is for the accessory apartment in an owner-occupied single-family dwelling on property located at 514 Rochdale Street, Auburn, Mass., map 52, parcel 7.
I will make a motion to grant the special permit under the sections as written, subject to the sale of the home, and I believe Gloria LaBeouf has put forth certain covenants already, subject to the sale of the residence where the special permit would cease upon sale of the residence.
Okay, do I have a second on that motion?
Mr. Chairman, I'd like to second Ms. Chicolo's motion and for discussion, please.
Oh, absolutely, please.
I would agree.
So, and if I may.
Yes, please.
So one point of clarification for board members is that I want to just affirm, and I know this question wasn't asked this evening, but it has been asked previously of the applicant, that there are no additional structural or internal changes planned for either the accessory apartment or the home itself. And I know that we've addressed that question before, but just for the record this evening, I wanted to confirm that there were no additional changes, structural changes, internal changes planned for the apartment or the existing structure. For discussion on Ms. Chicolo's motion, I would submit that based on the conditions set forth, that this would be an accessory apartment utilized for family use, and this would follow the applicant's ownership and cease at the applicant's no longer owning the property, then I would stand with my motion to approve, my second to approve with those conditions.
Okay, so I just want to be clear on your issues with it. So Mr. Chicolo made a motion to approve that would grant the special permit under 9.3 and 9.3.12.6. It would be void upon sale, and might I add also transfer in the event that may occur?
And it would
And
be...
residence.
And it,
I'm sorry?
She has to live there.
Right,
And
okay,
residence, not just sales. She has to occupy it
physically
as the owner.
In residence.
As stated.
That says that in the bylaw.
thank you.
As stated.
All right, so it would be void upon sale, transfer, and as long as she is in the residence, correct?
Yes, sir. Mr. Chairman, for overkill, I'm assuming transfer.
That's okay, we're going to get this right.
Yes, sir.
That's very important because I have a very long decision to write. I'm sure I'm very clear on it.
Absolutely. And transfer, I would assume would imply any inheritance forward that would transfer to any of her heirs.
That was my intention, whether it be a gift, a one-time gift, transfer via however method it
Yes.
might be.
Definitely on the same page, just
So-
mentioning for clarity. Yes, sir.
Yep. And I will clarify that in the decision. And it would be for family use only, I believe, is what the standards that you required in this, if we grant the special permit. Correct.
I affirm, that's correct.
Are there any other conditions that would be, the board would be willing to add or would like to discuss?
I just, as a matter of discussion, I think it might be necessary to just briefly mention what the standards for accessory apartment is. I don't think you necessarily have to write them all down because they're in the book. But in a brief summary, the outside existence to the house has to remain. I think that's satisfied. It's only going to create one apartment. That's satisfied. The lot requirements, I think we have the right to have discretion on whether or not it meets the lot requirements. She's going to live there. That's D. I want to address the square footage issue because I think for the abutters that is something that they had put in their brief. The bylaw states that it should be no more than 700 square feet. Based on what we've been given for numbers, the total is 2,000. The apartment is 1,500. The accessory apartment is 500. Leaving us to deduce that the original structure was 1,500. 20% of 1,500 is 300. Yes. So I think that we just need to think about the actual numbers of the square footage. I just think that also it does address parking. I think we've talked about that in prior meetings about the driveway, that there's not enough room for parking spaces. And it does say, of course, with state building code, which I think we've put to rest, that Caleb has gone and actually looked and made sure that it did, in fact, address the parking. I just wanted to sort of hit each of the points on here because I think for the decision it's important to say that we feel that they do meet all the requirements.
So, Mr. Chairman?
Yes.
After listening to my colleague, we would be granting relief under the 20%.
Yes.
So I'm just going to be clear here before we move forward, because we've already, we've added a few things here. So go back to the beginning. We're talking about this special permit. If it is granted, that it will be void upon any sale, transfer, and transfer has several definitions, as we discussed. And Ms. LaBeouf must reside in the property, otherwise it becomes null and void. It must be for family use only. It must be maintained less than 20% of the accessory use requirement under the bylaw. And all parking restrictions, I believe is something you mentioned, would also be abided by.
Yes, I believe we did establish prior meetings that the driveway was big enough for what is required.
It is.
Okay.
Okay, so are we satisfied with that? All right, so for the record, I have a motion to approve from Mr. Chicolo, and I have a second from Mr. Marin. I'm actually going to do a roll call vote, because I just want to make sure I keep everything clear here this evening. So under the special permit granting, Mr. Chicolo, your vote, please, sir.
Approve.
It's Mr. Marin.
Approved.
Mr. Cussy?
I'll approve.
Ms. Roach?
I'll approve.
All right, and the motion passes. For the record, I will approve. Yes, okay. So that's one. I'd like to make a motion, I'd like to request a motion for the 705 hearing, and I'm going to read the entire application again as well. Gloria LaBeouf, trustee, requesting a variance under section 5.4, table 1, note 6, and 9.5 of the Auburn zoning bylaws to vary the land area required for a two-family occupancy use from minimum lot area of 80,000 square feet, section 5.4, table 1, note 6, to an actual lot area of approximately 45,000 square feet. Do I have a motion on the floor regarding
I will make a motion,
The,
Mr. Chairman,
yes?
to deny the variance for the two-family
Okay. This would be
based
for the-
upon the needed requirements not being satisfied for a variance.
So just to be clear, though, we're talking about just the variance on the land. We haven't moved to allow the two-family occupancy yet. This is the third item on the agenda for this evening that we're
Right.
discussing right now. But you had mentioned two-family. I just want to be clear. This is for the
Right,
variance.
this is for the two-family as
Right, okay.
as written.
All right. But I understand, but I just want to be for the record that we're talking about the variance.
Right,
For the
and my
lot.
motion would be to deny the
Okay.
variance.
Do I have a second on the motion?
Second.
By all means, sir.
Second?
Okay, second motion to deny?
Deny.
Okay. All right, so again, roll call vote. Mr. Chacolo?
Deny.
No. Mr. Marin?
Deny?
No. Mr. Cussy?
Deny.
Ms. Roach?
Deny.
And I as well, deny. Okay, so on the variance issue, as you heard, that will be denied. So the final one this evening, the special permit under section 3.2.2.1 and 9.3 of the Auburn zoning bylaws to allow two-family occupancy use on property located at 514 Rochdale Street, Auburn, Mass., map 52, parcel 7. Do I have a motion on the floor for the special permit under 3.2.2.1 and 9.3?
Mr. Chairman?
Yes.
I would make a motion as stated to deny.
Second.
Okay, hang on one second. And again, for the record, roll call vote. Mr. Chacolo, your vote, please, sir.
Deny.
No. Mr. Marin.
Deny?
Mr. Cussy.
Deny.
Ms. Roach.
Deny.
Mr. Tatro was a no. Okay, so, as you've heard this evening, we have agreed to grant you the special permit to allow the accessory use apartment. And again, you've heard, I believe, the somewhat of a list of requirements that will be on the permit. I will be writing all of these decisions rolled into one, but I will specify each one individually also in that decision. And you will be able to receive that building permit from Caleb, the building commissioner, when it's ready. I'm certain that you'll be able to call him at the town hall, and he'll be able to take care of that with you and wrap those things up. On the variance issue, I think the board made a very wise judgment and denied the variance on that. And on the special permit for the allowing of the two-family, I believe that was, in my humble opinion, not met. I'm not speaking for all members of the board, but I believe, again, that was a very wise choice of the board. So I'm glad this could be resolved for all parties concerned. I hope everyone's happy with that. We did the best we possibly could. So thank you very much, and it concludes the hearing. Do I have a motion to move on to...
Motion to close the hearing?
Yes, motion to close the hearing. I apologize.
Second?
All in favor?
Aye.
Any denied? Okay. We'll give them a few minutes to exit, and then we can move on to our next agenda item. Okay. Lots of sorting. Yes.
Thank you. Good evening.
Thank you.
Thank you very much.
There you go. So I do owe the board one decision, and I want to be clear that it was my fault. I inadvertently overlooked the Verizon decision for Sulphur Street. That was my fault. We had several decisions to write. I had to catch up on a couple because of continuations. So I do owe the board that decision. I will have that. It's basically about 90% written, and I didn't want to submit it without it being complete and having a final review. So I will have that done hopefully for you by the beginning of the week, and we will clear up that. The next item is if anybody had the opportunity to review the February minutes of the meeting, and I have a motion to approve.
I'll make a motion to approve the meeting minutes from the February 19th, 2015 meeting.
Okay. Mr. Chacolo, for the record, is a second. All in favor? Aye.
Aye.
Any opposed? No? Okay. Excellent. And I believe that's it. Do we have anything else, Caleb, that you'd like to address before we close?
No.
Okay.
Thank you.
And again, I just really want to take the opportunity to thank you all. I know this was a very long and difficult hearing. It was challenging in terms of the layers that were involved in it. And again, one of the issues I had with this whole item is that I wanted to respect our building commissioner, especially Caleb. He puts a lot of work, hard work into the town. Our attorney, Robert Hennigan, writing his decision and submitting it for us, I think was critical in making the decisions here. So I really want to thank him also. And just to take the time to volunteer and do the efforts and get this thing squared away, so hopefully everybody involved is happy. So with that being said, do I have a motion to close the hearing?
Motion to close?
Second.
Second. All in favor?
Aye.
Aye.
Thank you.